trying to organize my thoughts. I don't think that we can make a habit at the Forest Hills Public Schools board table of second guessing constitutional law, or us as individuals going off on investigative journeys to try and interpret constitutional law. I think we have experts around us. I mean, this is like going to a hospital and having a doctor say, this is what you need, and the classic, anecdote of somebody saying, well, I'm gonna tell you what I need. People are experts for a reason. We believe experts around us. That doesn't mean they don't make mistakes. And certainly, if your 6 judges and 9 judges and everybody else and the rest of the legal system deems that whatever this is unconstitutional, that will come down and then we will change again, right? I mean, that's how, there are circuit judges and courts of appeals considering all kinds of matters in education. That doesn't mean we are stagnant and do nothing, while all of this makes its way through. There's no end to, legal battles over different topics, right?
It was not just churn law.
It was 3 independent law firms who specialize in public school law that are sending this through to.
And none of those judges in circuit courts and appeals courts are jurisdiction.
I also still struggle to understand the harm to kids from this. As I understand your explanation, I'm hearing your concern is that we're going to have more complaints filed, right? That because the standard is lower, so possibly more complaints can be.
So it is a violation of the Constitution, and it's a violation of First Amendment rights. I'm more concerned, not only greatly of our kids, and I'll explain in a minute, but I'm a little concerned, or greatly concerned about our team members, our teachers, and staff members that are going to be greatly affected by this. So we have, it's hard to explain this thing. The word, what do you think the word pervasive means?
Again, I'm not going to dissect constitutional rights.
This is what the new standard is. This is in the Title IX.
Is pervasive in both definitions in the old one and the new one?
It says severe, pervasive and objectively. Now it is severe or pervasive. That's changed.
Right.
So somebody can file a complaint based on pervasive.
Okay, and is that person, again, is that person, the person all
Okay, so we have a teacher that doesn't
resolve
call a student by the right name or the right pronoun and gets corrected, and then they file something against the teacher. That's what pervasive would do. So this is what we're doing. I'm telling you, and I'm not saying I'm an expert on constitutional law, but I am watching people who are an expert on how the judicial system, the executive branch and the legislative branch work, and I am paying attention to it. I'm not saying that true in law's not. I think they were given a task to take regulations and transform it into policies for Forest Hills Public School. Their job wasn't to dig into and find out what was going on in the circuit court and the federal court and paying attention to the Supreme Court.
I think every public school teacher in the whole state of Michigan and country perhaps is going to be subject to getting fired and all these violations, but we're going to protect our teachers being forced to apply not. Right? Everybody everywhere is considering this kind of like.
So what I'm saying
another
is,
example of pervasive is, for instance, if you have a student who is being sexually harassed by another student on a constant day-to-day basis, that would be pervasive. It might not be severe, but it might be pervasive. And now they don't have to be both severe and pervasive in order to be able to file a complaint. They can file it just on the fact that it's pervasive, even if it's not.
but now you're getting
severe.
back down to risk and reward, okay? So what you're doing is, the policy we have in place right now doesn't set us up for a lot more caseload. The policy that we're asking to adopt does. It sets us up way more for a heavy caseload for people just based on some of the language that was put in. It even says subjectively and objectively. We didn't even want parents to come talk at the mic because you didn't want to listen to subjectively comments that were being made on this, but now we're going to have to deal with it when it comes into this. I'm saying is that we have a violation of constitutional and First Amendment rights.
In your opinion.
No, it's not.
In your non-legal opinion.
Even in other people's
I'll say it in
In
my
other
non-legal opinion.
in other people's
but
opinion
I'm
as
gonna
well,
base
but
it
your
on
non-legal
the
opinion.
Supreme
Court
Court
says it.
I'm gonna base it on what's happening. In the judge, there's the judges and the injunctions that are filed on this. Now, we can table it and watch it play out and then adopt the policy, or you adopt the policy and watch it play out damage has been done in the last month when this gets put into place. That's.
Based on the court rulings from Friday, I would think Troon would have called our superintendent and said, put this on hold, there's a big change. That's their job, is to make sure that we are in line with legal standards in the law. So if they know what's happening in the court system, so if our attorney didn't think that that affects this policy being enacted, then we still need to be in line with the law. That is our job as a school board.
It's not the law.
I'm just.
And just to be clear, my reach out was after Friday. So
Right.
to make sure that there weren't changes that
Right.
we need to recognize based on what happened on Friday. But important, the injunctions are issues that are against OCR's enforcement. It's not related to specific school districts. It's OCR's enforcement. That's what the injunctions are. And the state of Michigan has not been part of that with the Elliott Larson Civil Rights Act that was in place.
The injunctions are based on protecting the original Title IX and the things that are coming down for there's several classifications. I wanna say Moms for Liberty is one of them. Our parents can file with Moms for Liberty to protect their school specifically, so they don't have to abide right by the Title IX things. As of last week, we did not have any parents that had signed up, but we did. Moms for Liberty has not released that list yet because it's 130,000 more that they have, that they've pushed through. So, I mean, we could wait for that as well too, but I would like to table it because the list is, from my understanding, I talked to the public, we have a lot of schools that are covered under the Moms for Liberty umbrella in this for what is happening in the court. So what that would do is that would eliminate that school from being under the new Title IX. I'm asking for time because it's a lot to unpack. This is complicated. I don't pretend to know the law, but I do pay attention to some of the things that are happening out there. I've asked questions. I'm trying to get the answers and I'm trying to bring it forward as best I can, and it's complicated, I will say that. It doesn't hurt us anything to table it.
It does.
It does.
We have a
For
problem,
kids.
we have liability.
Right.
It doesn't hurt kids because we have a policy in place. So you're
Not
saying
the
the
new one, Holly, we have to be in line with current law, and
not
that
law.
changes things.
It's
That's
not
not
a
law.
law,
It's
though.
It's
law.
law.
regulation, so it
Our
changes.
lawyer told us-
It's a regulation.
Our
So
lawyer
let's
told
be
us this needs to
specific
be a
about that.
policy. If whatever the title is, whatever the terminology, they are saying you need to have this in place, because if something happens, you will be liable.
So I would offer this as well. So whether you call them regulations or laws, and they are two different things. When you have a policy provider, part of the reason you have a policy provider is they back their policies. If you are ever, sued, or you have a case where somebody takes issue with you implementing your policies the way that they have written them, they would cover that and provide that. If you don't follow their policies that are based on regulations and laws, and then you do have suits, you do not have protections as a school district or individual employees that are acting deliberately indifferent. And that's where, my concern comes in. It's not whether or not, when it was vetted initially, how it was all created, like that part, that is a whole nother branch. I totally get all that. What I have to look out for, my responsibility is the students here and the district here, and what our liability is if we move forward with them, and what our liability is if we don't move forward with them. And part of the reason we're at beyond August 1st is because I asked for extra time to have us take a look at it, recognizing other than summer school, we didn't have school in session, so we had fewer employees, fewer students. Now that we have students in session, that's why I have moved it forward, and that was when I talked with Troon, recognizing that later in this month, prior to school starting, put us on good legal standing if we had any issues. So if we do move it past, we have that period of time that we are not following policy based on the regulations, and so we do have some liability there. So I would just share that when you do deal with policy providers.
Can I ask you a follow-up question then? Because again, I think your point and objection is laid out well. I think we understand it. And I think there's liability on both sides, it sounds like. I mean, totally theoretical
sure.
liability on both sides. Would you, in just your completely opinion, is there more liability in pushing this through, or is there more liability in not pushing this through tonight?
We're at,
Different kind of
let's
liability.
clarify.
Different kind of liability.
We're not putting it on the table forever, it would be for one meeting.
Right, tabling for a month, yeah.
Well, I think the other part to recognize is that if there was something specific to a Forest Hills Public School or Forest Hills Public School District or all school districts in the state of Michigan, then we would be back here talking about that we need to change our policy based on the legal guidance, and we would move forward at that point in that way.
Yeah. I think when you're given legal advice that you need to have these policies, there are ramifications potentially if we don't follow them. It's our job as the board, it doesn't matter whether we personally agree with what that law or regulation is. That's not for us to say. Our job is to make sure that the district is protected, that kids are protected. So I would suggest that it makes more sense for us to vote on this and put it into place right now. If the law changes, if the regulations change, if whatever it is changes, and they say, oh, no, that's, you know what, it's not constitutional, you can't do that. Well, it's very easy to then change that policy back to what it was, stored in a drive somewhere, and we can put it back. But we just wanna make sure that our policies are always reflective of the current legal advice that we are given.
So my question is in the new policy, where is the definition of gender identity and gender expression? From true in law, where is that in our policy? There should be a definition in there because there used to be a definition for sex, right? They're trying to change the definition from sex to gender identity and gender expression. And I would ask, where in our policy does it state where the definitions are, from which we should have in there what the definitions are based on those things. Gender expression, or gender, we need to define those things. That's not in there. There's a couple other things that are not in there as well either. You have, hang on a second, let me find it. That's the main one. There's no definition. I know that the thing got changed from parent/guardian to just parent, but in there it states what the parent is, and it's you can go in as legal guardian. There's no definition in here from true in law, and I think it needs to be in there. But gender expression and gender identity, the definitions of that, because it's going to be left up to an interpretation. It's broad right now, and I think it needs to be defined, and that should be in there based on the ruling that, the regulation that is coming down from the Department of Education. That's the one piece that they're changing. So if they're changing it, then that needs to be in there as a definition so people understand, because otherwise you're gonna be filing stuff, or people are gonna be filing a caseload on something that there's no definitions on.
Okay,
So that would be another reason I would want to table this. I think true
Putting
law.
it simply, we are just looking at tabling this so that the questions that you are asking right now could be answered. Correct.
Correct.
So are we ready to move forward with this?
I think we are, and I mean, I
And
would
it's not
like
just
to
me
put out
being
the.
answered. I think there's a lot more out there to unpack.
I just wanted to clear.
I know, but I think
I would
what
like to
we're looking
also
at is
mention
tabling or not.
publicly, Holly, that you were given this policy a week and a half ago, almost 2 weeks ago, and asked, hey, and everybody was given the policy. If anybody has any questions about this, please get them to Superintendent Kirby, so he has time to reach out to the appropriate authorities and answer those questions. If you didn't ask the questions in enough time to get the answers, that's incumbent on you to do that as part of your job as a board member, not to all of a sudden come and throw questions at the board today where we don't have the resources to be able to try to answer those questions.
Okay, I can't help but say though, Kristen, that she made it clear that, she said 300 so pages was a lot for you to be able to read in
I
that
didn't say it was a lot for me to read. I said there was a lot. There was a
Right,
lot there to
right.
unpack.
But
I
was just offended,
Right.
just
No,
saying
no,
that
I'm just
you
saying.
said you needed more time.
I'm just saying that I'm gonna just say I don't feel comfortable in voting on this right now in the state that it's in light of what is happening with the injunctions that are going on and what's happening. I'm not asking the question, did did the Department of Education not go through the Congress to get authority to change it? I already know the answer to that question. What I'm doing is I'm bringing and sharing light of a discussion that needs to happen, so we're all aware of what we are actually about ready to do here to team members, staff members, and our students. It is going to change the face. Also, some of us have daughters at this table, right? It's going to change a few things with that as well too.
All right, I just felt like we are kind
I'm
of
just
covering
saying,
the same ground
well,
again.
all I'm saying is that there's some things that are in the Title IX that are not in our description, that from true and law that need to be, are in the thing that is in the law, it's supposed to be. I think we should revisit that if you're gonna have the full policy of what it is for the Title IX. But the other thing too is I really think we should table this so we can actually have some time to look at and unpack. And we do have a policy in place right now that protects children based on Title IX's 2020 revisions that we have adopted.
We do, but it's not a current policy, and by law, we should be current, and I'm so sorry, but my question is, can we get clarification? Lifelong learners, can we ask some of Holly's questions? Is that putting too much on you to say, can we get a definition of gender expression, and if it's not there, why not? I don't want you to have to spend a ton of time, but if you have concerns, is there some way to get some clarification on this and still support the policy as stands, so we are in line with, legally what we're supposed to be in line with from a state and federal perspective?
I have been writing down some follow-up items. I was thinking
Right.
3115A or something
Yes.
along those lines had definitions.
So
I'm not
that
sure
seems
if those are
appropriate.
in there
It
or
does,
not.
but no, we looked, gender expression's not in there, so why was picked?
Pervasive's not in there either, right?
Yeah.
I mean, there's
Right.
all kinds of words that are
So
not
if that's something that will help us all understand this better and be sure we're doing right, but I mean, again, legally, this is what the lawyer said we have to do, so does that mean we meet again next month and have to add some clarifications and modifications based on our superintendent's discussion with Troon, possibly? Does that seem
Right.
logical?
Right. My thought is, especially knowing that we've had a conversation with Troon
Yes.
since Friday,
Yes.
and they're still in their legal opinion did
This
not
is where we
say
need to
you
be right
shouldn't
now.
go through with this.
Right.
And knowing that if we choose to table it even, theoretically in the month between now and the next time we consider it, there is some potential liability there for the district. But by not having this updated policy in place,
I wanna correct
then
that.
why don't we just come back and.
Wait, I wanna correct that true and law did not say we should not go through with it. What the question was asked is, did the Supreme Court ruling what we're doing here at Forest Hills Public School? The question wasn't asked if we should go through it. That there's
Actually,
Yeah,
superintendent Kirby did
that
ask that
was,
question.
that was
That-
explicitly asked to.
that it was.
Two different law firms, yes.
Okay.
So I'm not comfortable
Alright,
having the liability open for a month, I would just like to voice
Well,
that.
we don't have a liability
Alright.
for months.
I think
Well,
we
we do.
have a policy in place.
we would have
We don't have a-
liability.
Caledonia Public Schools just tabled
Yeah,
theirs
we-
because they had the same concerns that are being presented here tonight and they tabled.
Okay, so.
And Lowell did as well. So we're not the only school. If we table it, let's just get it and get it right. If this is a law, then make sure that the policy reads. But I think the definitions there are gonna be a key factor because that's gonna zero in on what this means, because that's what got changed. It changed the verbiage from sex to gender identity and gender expression. So let's give.
Gender expression is in the Elliott Larson code, we see it, and we say that we're referencing Elliott Larson, so it's probably all in there, and we can still be safe and get answers to
Yeah,
continue
we
the
can still
discussion.
get those answers to you,
Still
but I
learn
think,
more.
Our liability protected.
I think we need to take the vote on whether or not we want to approve this
Do
policy.
this month, and then figure out next month.
Well, I motion that we table this to next month.
Okay.
Motion, the policy or the procedure, it's not a law, it's a procedure to put in place of the new Title IX, and it's new, that we motion to table it to unpack it a little bit more.
Thank you. Do we have a second?
I'm sorry, Holly, could you repeat your motion, please?
Yeah, I motion that we table, series 3000, specifically 3115A, all of the components that are within Title IX's new recommended, regulations from the Department of Education.
Okay, we have a motion. Is there a second?
A second.
Okay, can we please have a roll call vote on whether to table the vote on the, board policy 311 something?
Five.
I'm just gonna, point of clarification, does that mean we could technically vote all the other policy into practice and just leave that one section out? what specifically are we doing? If we're-
Technically, the board policies are all in here together as
Right,
one vote.
so we have, so it's not
It-
31158,
it
it's
would be all
item
of the
VA2.
policies.
Right, okay,
Oh, yeah,
okay, yeah,
sorry.
okay.
Okay, so it would be voting to
Table all
table
our
all of the
policies.
policy approvals until next month. Can we have a roll call vote, please? Yes, Dr. Dr. Mashad?
No.
Ms. Steinmeier?
No.
Ms. DeBoer?
Yes.
Ms. Monk?
No.
Mrs. Cavell?
No.
Dr. Paulson?
No.
Mrs. Tryon, yes. Okay, that passes. That we will not be tabling it till next month, which means that we will bring it up for a vote right now. May I have a motion to please approve board policy, from consent group being 5A2? Sorry. Can I please have a motion to approve consent grouping, 5A2 board policies?
Oh, I
So
still
moved.
have I still have another one, so.
Second.
Okay. Are there any further, I think we've covered the discussion on the board policies.
Great. No,
So-
I had one more that we pulled out as well too, in the 4,000 series.
Okay.
4105A, talks about removing completely about, adults and staff members not, we have it in place right now that, adults and staff members are not allowed to encourage a student to have an abortion. And the request on this is actually to remove it completely. What came down was that we don't need it any longer. However, I think it's a great policy to have in place. I wouldn't want an adult encouraging my child to get an abortion. And so I move that we, leave the policy in place, to protect our students.
Is there a difference though between, because it is no longer a law that they cannot offer them advice? That's why it was suggested that it be removed, not suggested, it was said to be removed. Because it is no longer a law, so they can no longer be held legally liable for offering that advice if they do.
Correct.
But, so is there a difference though, and I understand your concern, I have the same one, but I think there's a difference, right, between what is board policy because it's law or not, and what we would consider best practice administratively in the district, but they're not always the same. Like, we can say, we certainly hope that there is a level of professionalism by our staff, that this is not what happens, but we can't make it policy because it's not a law anymore.
Is that true? We can't make policy unless it's in line with law?
Well, there's administrative policy, and then there's the board policy,
If the
correct?
law-
Yeah, I mean, I think she was generalizing, but there are policies that are not directly related to potentially a law, but
Right.
But this one is.
yeah, that one was removed because at one point in time, it was a law that there would be discipline if that occurred. That law was removed. That doesn't mean now that as a district, we are gonna practice, making recommendations. That is not the case at all. It's just, it was put into place because it was put into law. Before that, it wasn't something that our staff would do as far as making those recommendations and referrals. It just became a law, therefore it had to become a policy. It's now being recommended for removal because it's no longer a law, but our practice would not be to then begin to make referrals. That is not something that we would be doing.
Right, that's why I'm recommending that we leave the policy in place, because the law doesn't say we cannot have the policy. It just says it's no longer required. I think it's a good.
But it's not enforceable either. It's not, if we had it in there, it's not like no one can be held legally liable for that.
Unlicensed
Well,
practice
we
of
can have
medicine.
recommendations in the
Policy, we
district.
sure can.
You can have a note in the file or whatnot.
Yes, but I'm
Yeah.
saying like, you can't file criminal charges
Right.
against that individual
Right.
anymore.
Unlicensed practice of medicine.
There are probably a lot of unspecified things that our teachers do not practice, and we would not want them to practice that are not specified in our policy.
That's fair.
That's fair.
Yep, very fair, yeah.
So this is just another kind of precedent question just for,
Right.
If you don't want them to practice medicine.
This is not time for public comment.
Then you probably should let them know that.
So, all right, let's go ahead. I think we've heard concerns. Is there any further discussion? board members, CJ, you look like you're.
I'm just synthesizing, I mean, a little bit. I mean, again, I understand the concern too, and it's, you know, but is it, as a matter of practice, is this something that we would do for any other subject that we didn't, you know?
Right.
Yeah. Okay. So the motion on the table is what exactly?
It's to approve.
To keep.
The motion was to consider approving 5A2.
All of our policies.
To keep.
And the reservation
to-
was the
to
300
pick.
series, 3011A, and now the 4105A, which is about the removal of the policy
Right,
related.
as a whole. And the
So
point of
the-
clarification, if we were to say no to all of this, then we would have liability over all of these policies that are not
Correct.
going to be enacted and
Because none
therefore
of the
not be up to
policies
date.
would be, none of the policies
And
would
so
be
our
implemented
liability would
tonight.
be
I mean,
further.
let's also like be
Technically.
objective here. I mean, we did this last year at this exact same time too, and we postponed them a month to get more answers. I know the situation was different. I know there was more to digest last year at this time than we have this year, but this is not like it's an unprecedented
Right.
decision.
I think what I wanna say is that we have laws in place and policies in place that, that cover everybody. Everybody has the same rights under the law. And I think this, it's giving extra special.
I guess I would say it's
I think
unfortunate
so.
that we did not know your questions, Holly, ahead of time, because I think it would have,
But you have the power to
But wait,
table
Holly,
it,
wait,
so
let me
yeah,
finish.
okay.
I wish that I had known your questions ahead of time, because I think it would have maybe saved this discussion potentially, because we could have made this decision to postpone it ahead of time to get more answers. That being said, we didn't, and here we are now, and so that's why I feel comfortable saying, yeah, I'd like more information. I know that doesn't help all the other policies that I don't have a problem with, or that I don't need more answers to. So I'm saying that I understand your concerns, and I don't disagree that there is maybe some more information that we could get. But that doesn't mean that if we get more information and it's still not what you personally endorse or what I personally endorse, that we still don't vote yes or no on it. I'm just saying I agree that there's maybe some more information here to be sought.
Yeah, and I think Superintendent Kirby has been writing down a long list of questions and concerns. You still have the opportunity to converse with him later and make sure that he has the list. Anybody has any questions that they wanna add on, he can go in and get some additional answers for you. I think the important thing to remember here is at this point is we are looking at a whole host of board policies, some of which, if we don't pass them, could theoretically open up the district to liability if we don't pass them. Doesn't mean that if we get some information from Troon and they say, oh, actually, yep, things have changed since you just met on Monday and now it's Wednesday and there has been a change, okay, then we can change our policies next month to be reflective of that.
And or if you want the Elliott Larson specificity about gender expression actually in our policy versus just referencing it, those are things that can happen in the future to add clarity. But we are, from a liability perspective, at least protected today, pending some discussion Superintendent Kirby has with our legal counsel to make sure that clarity's in there.
The changes to Title IX are coming from the Department of Education. It has to be made to the Title IX updates of, you know, so I'm just saying,
Yep.
it's not the Elliott Larson attached to it. It needs to be specific and.
You know, you said gender expression and we're covered. I mean, but if you needed more clarity, you want it specifically stated policy, I'm sure Troon can do that for us. But right now, our policy references Elliott Larson, some gender expressions identified. So we have opportunities to add clarity, you know, with time.
And I don't wanna make this even more complicated, I truly don't, but we don't have the ability to siphon out a specific policy and say, we're going to learn more about that and not implement this specific policy, but we're going to approve the 150 other ones. I mean, I know it's one agenda item, but I only ask because, right, why not learn a little more about some of these specifics, maybe if we wanted to, but I don't wanna pause the beneficial updates to 200 other policies, you know, for these questions that we're supposed to have known the answers to and had this discussion before, you know, or gotten more information before this moment. So that's my question. Again, and being rational about risk, I don't think that removing that policy is going to cause 100 teachers to go and talk to kids in the next 30 days about having abortions. We need to be reasonable about risk. I'm not saying it's 0, because theoretically it wouldn't be a policy anymore. I get that, but.
But it's not a policy, it's not a law
I know,
anyway.
I know, but they would, in theory,
Hopefully.
still suffer
But it's a good
ramifications from the
I'm
district if they.
not saying it's not.
Right.
I'm just saying it's not a law anymore, and so we
Right.
don't have a lot of like,
But the district could put on, right,
Yes,
the district could do
100%,
things,
yes.
there is still some
Yes.
reason to not engage in that practice as it lives in our policy if you're an employee of the district. And I don't think removing that is gonna cause a lot of that behavior to happen, and if we learn more in the next 30 days, so my argument is we can approve this now, all of this, learn more in the next 30 days, and if we need to change 1 or 2 things somewhere else, we can do that in a month when we all have learned a little bit more. And that's probably the less risky, less liable path than wholesale not approving this entire packet of policy updates, is my thought. So if we don't have the ability to pull out a specific thing, then that would be my opinion that we need to listen to.
okay, and and you know that, we are not allowed to pull out a specific.
No, that's my
If
question.
You're asking,
Yes.
you're asking.
100% asking, yeah, I really don't know.
I would like that answer too.
Yeah, the way that this was put together for the board tonight, it was
A consent grouping.
a consent grouping of all of the policies. So, I think we can move forward now with a vote, of whether or not to approve 5A2 board policies. Could we have a roll call vote, please?
Okay, Dr. Michaud,
Yes.
Mrs. Niemeyer,
Yes.
Mrs. DeVore,
No.
Mrs. Vaca,
Yes.
Ms. Koval,
Yes.
Dr. Paulson,
Yes.
Mrs. Tran, no.
Okay, thank you, everybody. All right, we will now move on to informational items.